questions in the case of RAFIU and others versus the Secretary of State for the Home Department?
Yes. Shall I explain why we've listed this for directions? Because we think we need to sort out the parameters of the appeal hearing prior to the appeal hearing taking place. And in particular, we need to look at the composition of the appeal in respect to the original grounds, the new grounds, in the light of the respondents having indicated that they no longer seek actively to oppose the appeal. They're not, as I see it, agreeing to a consent order disposing of the appeal. They're simply no longer taking an active part in it. So we have the original grounds.
Yes.
And we have the new ground A for which you've been given permission.
Yes.
And that raises a new issue of law which wasn't raised either by the entry clearance officer or before the FTT or before the upper tribunal. So first of all, in respect of the original two grounds, clearly those need to be determined.
Yes, unless ground A were to be determined in the Secretary of State's favour, in which case the jurisdiction issue would have been settled in the Secretary of State's favour, and the other two grounds would fall away unless the court chose to express a view on those.
Yes, I understand that, but I'm focusing on the second two to begin with,
yes,
just to see how they, subject to your point about ground A, they would need to be determined.
They would.
And they would need to be determined on argument, despite the lack of opposition on behalf of the respondents.
My lord, yes.
Might not take long, but there would still need to be a hearing. Now, so far as ground A is concerned, that raises an issue of law that has broader implications.
Yes.
Is this the right case in which to determine that issue? And if you consider that it is, how is that going to be done in a way that enables the court properly to hear all the arguments relevant to that issue?
My lord, 2 points. On the first question, is it the right case? It's certainly at this stage the only case that those instructing me are aware of. What I'm told is that there are active cases filtering through the tribunal system, but there is no one way to be able to search the system so as to say what those cases are. What I can tell the court is that there have been 3 decisions of the upper tribunal, 1 reported, which addresses these issues. What will happen as those other cases filter through is that they're drawn to the attention of the expert Home Office teams, who then become aware of them. So, still on your lordship's first question, while work could be done, for example, to send messages to various teams to identify those other cases, we can't give chapter and verse.
So hold on, you say there are 3 decisions of the upper tribunal,
there are 3 decisions of the upper tribunal
already,
yes,
which
already
specifically address the applicability of Regulation 16. I think that's the primary focus of your argument.
They do, yes, albeit in slightly different context. So the reported case is a case called James, and essentially...
Sorry, could you give the reference?
Yes, it's... One moment. It's in the authorities bundle that was prepared. I'm so sorry, James is unreported, so there is no reference. Unusually,
did you say James?
James. It's referred to in tab 16 of the authorities bundle. There's a sideline passage at paragraph 38.
Just a moment,
Sorry, in tab 16.
Tab 16, paragraph 38. This is a reported case of the upper tribunal called Osanai.
Hold on. 30. Yes, I see that.
Your lordships will see that cross refers to a case called James. The first reference to James is at paragraph 4 of that decision.
Can you just help me? So, which way did this decide?
It decided...
In accordance with your argument, or...?
Obiter in accordance with my argument, but it was dealing with a different point, because there's a distinction between decisions taken prior to the end of the transition period and then decisions taken after the end of the transition period. This was a case where what the upper tribunal effectively says at paragraph 38 is we're not going to follow what happened in James because this is a pre-transition period case effectively. But what it proceeds on the basis, in effect, that I'm right in my argument.
So in James, unreported, the upper tribunal, is this right? Is
Correct.
it is the upper tribunal?
It is, yes.
Pointed out that regulations 16 and 20 are not part of the EEA regulations, which are preserved by the 2020 regulations.
Yes.
And that was not appealed.
That was not appealed.
Right. And that was not obiter.
That was not overturned, but is unreported. So
If it was an important issue of law, why is it unreported?
I don't know. That's in the hands of the upper tribunal.
Yes, but
It may be because the respondent in that case was also in person. Perhaps the upper tribunal
Right.
thought it hadn't heard sufficient argument.
Right.
At the point. In the Osanai point, which was in fact reported, the appellant was also in person. In fact, in
I
the
can
three
see. Yes.
in 3 cases where the upper tribunal has considered this, the Secretary of
So we've
State
had 2. We've got James, Osanai. What was the third?
The third one is called AZ, and as I understand it, also unreported, and again decides the issue in the Secretary of State's favour. So that's a decision of the 7th of February 2024.
Right. Okay.
If it would help the court, we can give the court a note, which...
No, don't worry. Not at the moment. It may be turning on how we proceed. So this issue has been addressed, but not yet in a reported form.
Correct.
So you're referring to these cases to explain why it's the Secretary of State's view that this case is an appropriate case for this issue to be addressed.
Yes.
For the first time only in the Court of Appeal.
Yes.
But in the cases which you've just mentioned, at least to some extent, the argument was live. I appreciate those questions of timing, but the applicability of the regulation as opposed to its application
Yes.
has been an issue in the other cases, but they didn't get appealed.
Precisely, my lord.
But life being what it is, in the case where it wasn't raised, it now has been appealed.
Precisely, because when it crossed my desk, it seemed to me that the issue absolutely needed to be raised in this court, and that in the other cases the Secretary of State did raise it. The argument in the upper tribunal in those cases post-dated the argument in this case, so unfortunately and regrettably in the upper tribunal, and indeed in the entry clearance officer decisions, the point wasn't anticipated.
Yes.
Which is why those instructing me understandably were reluctant to raise it, but with hindsight we felt that we should raise it. But it was argued in those other cases and decided in the Secretary of State's favour, albeit on slightly different facts. The only real distinction between this case and those cases is that they weren't admission cases, and your lordships may have seen in the skeleton we anticipated a point that could be taken against the Secretary of State in relation to one of the regulations, Regulation 11. That wasn't an issue in those cases. Our position, as your lordships will have seen, is that that doesn't make any difference.
Yes, I must admit I was trying to work out just briefly the relationship between regulations 11, 12 and 16. So your submission is that the Secretary of State would want to pursue ground A
Yes.
to a determination.
Yes, that's right.
Now, if that happens, how is it going to be properly argued?
Your lordship's second question, we would suggest that the court might wish to consider appointing an advocate to the court in the circumstances. My instructing solicitor has prepared a note on the relevant processes, which I could hand up to the court now, if that would assist.
Well, can you just remind me what the process is?
The process is that there is a practice direction, which is practice direction 3F, and the court, in paragraph 3 of that practice direction, there needs to be a danger of an important and difficult point of law being decided without the court hearing relevant argument. And in those circumstances, the Attorney General may decide to appoint an advocate to the court. I have certainly seen that done in one case in practice in this court, which was a case called Carrington, where at that point there was an unrepresented party, and the court in that case, and there is a judgment of the court effectively giving directions, and in that case the court did appoint an advocate. It is the court that makes the request to the attorney, and that there is a process for that. Usually the court lawyer does it according to the research of those instructing me, and then directions are set for the advocate to provide written submissions and then to make oral submissions.
Do you think someone might want to argue that you shouldn't be given permission to argue the point in the Court of Appeal for the first time?
I suspect two reasons. One, that they would, as I had read the order of Lord Justice Lewis, we have permission. But second, I imagine that an advocate to the court would potentially anticipate a need for the point to be decided. It won't in fact have any personal impact on the respondent in this case, because he's explained to the court that he's pursuing other avenues. So in that sense, it doesn't disadvantage the respondent personally. And so far as the test is concerned, and we address that in paragraph 50 of our skeleton, one of the key tests that this court has applied is it a pure point of law? Is there any need for new findings of fact? It is a pure point of law. And the third reason in my submission that I suspect an advocate may not say it shouldn't be argued is that it's a jurisdictional point. And while the Secretary of State has been neutral as to whether the court should hear the point, if there is an issue of jurisdiction and the law that can properly be applied, then one anticipates that the court...
Whose jurisdiction is it? Because I was puzzling about that. It doesn't go to the court's jurisdiction.
No, it's effectively... jurisdiction is perhaps the wrong word, but effectively it's is this law at all? Is this law at all that the court can apply? In a sense, it's a broader jurisdictional point about what law the court can or can't apply. And one might say, well, on the 1st of January 2021, after exit, the court didn't have jurisdiction to apply EU law because Parliament had said EU law was gone. So it's jurisdiction in that sense.
Can I just ask rather a mundane question? When an advocate of the court is appointed and the Attorney General has you can't require the Attorney General decides whether or not to do so, and if the Attorney General decides to do so, it's paid for by the Attorney General.
Yes, it's done by GLD, and I assume that's done. Certainly what I'm told is that decisions to appoint an advocate are taken by one of the law officers personally, and they decide whether it's appropriate to provide such assistance and what form that assistance should take.
So does it have to go with a note explaining what the important and difficult point of law is?
And that is explained in paragraph 9 of the practice direction. So it says the court should make the request to the attorney, and what the court does is set out the circumstances which have occurred, the point of law upon which assistance is sought, and the nature of the assistance required.
Right.
And does the court think it needs written submissions, or would it also want oral submissions? And the request is made in writing and then accompanied by any relevant papers. And I'm going by the note that my instructing solicitor prepared, because obviously there's in-house expertise within GLD, and he has spoken to colleagues about
appreciating that there are distinctions to be drawn here. In practice, if we took the view that, firstly, you don't appear to be arguing that this point could be decided without, at this level, where it hasn't been dealt with in the other courts, without there being the opportunity for counter-argument.
Well, certainly I would do all I could to draw, obviously, any relevant authorities, obviously any relevant statutory provisions, and to answer the points that I think could be made against the Secretary of State. Of course I would do that, but the court may think that is not sufficient, and the court would want to hear on a difficult issue like this.
Well, it wouldn't be any reflection on what you have done. It would be in what are pretty extraordinary circumstances that an issue is arising
Yes.
at this point for the very first time, that in those circumstances there would seem to be an enhanced need
Yes.
for there to be the opportunity, at least for balanced argument. I mean, if the advocate for the court were appointed and said, I can't find fault with anything at all that Ms. Smith has said, well, then that's a useful exercise in itself.
Indeed.
But it would have to take place. Now, let us suppose then that we were satisfied that we needed this counter-argument and that the only port of call was the attorney. It would be open, would it not, for us to invite you to present, as it were, the request that would be sent to the attorney for us to consider as a draft, because you have the information and have done all the work on this.
It wouldn't. What I could do was hand up this note, but there are then strict divisions within GLD, so those instructing me are cut out of the process, and a different lawyer within GLD will deal with it. So they would, I assume, what would happen is that the court
Yes,
would see it.
but the way I'm putting it is this: that
We would want a draft.
we would want a draft
We're not going to draft it
ourselves.
Yes, I think what happens is that the court, this court's lawyer liaises with the government legal department,
Right.
and that
Yes.
it's done by a court lawyer.
Okay.
And then the court, I imagine, but I don't know because I've never been involved on that side, would see it. But certainly we would then stay out of the process.
Yes, I understand that, but what I'm talking about is in circumstances where you wish to argue something that you didn't argue below.
Yes.
There seems to me to be a strong argument to say that you can do the work to actually provide the court lawyer with the information that is needed, rather than asking somebody who's not been part of this to do it from scratch.
And insofar as that's consistent with the processes, of course.
Exactly. That's why I said I realise
Yes.
there are distinctions
Yes.
to be
Of
drawn in
course.
mind.
Of course, my lord, we will absolutely do all the...
But you can set out the information that's covered in paragraphs 3 and 9, can't you? You can set out a summary of why this issue, how and why this issue has been raised, why it's argued that it's an important issue. You can you can provide all that information.
And of course, we would have to approve it. I mean,
Yes.
it would be.
Yes, I'm being told it is then approved by the judge. So I suspect what would happen is that those instructing me would provide it to the court lawyer, and it would then come that way to your lordships. But of course, we will absolutely do whatever we can to assist.
Now, let's suppose that everybody having done all that work, the attorney was not satisfied that this was important enough to, as it were, dip into the common fund in order to instruct somebody. At that point, one could foresee, and let's hope it didn't happen, but one could foresee that this court might take the view, well, in that case, we can't decide the point.
Yes.
I mean, but we're not there yet.
Yes.
But I just wouldn't want a direction that the attorney be invited to provide an advocate to be selling the pass that we'll decide the case if the attorney doesn't want to.
Understood, my lord, and our skeleton recognises this issue has reached this court in the most undesirable way, which is why we were neutral in effect as to whether the court should hear it out of fairness to the respondent and obviously in the interests of justice and the overriding objective. So we hear that, we take that point.
So would the sequence of events then be for a direction from this court that the invitation be issued to the attorney to appoint an advocate to the court
In a form to be approved.
in a form to be approved, and for us to invite you and thank you for assisting in that process, and for a decision then to be taken as to the onward progress of the appeal in the light of the attorney's response. That if leaving aside what happens to the ground 16 to the regulation 16 issue, the actual individual appeal will go forward either with or without ground A.
Yes, my lord.
But there's no point in us listing a hearing in relation to ground A until we know in relation to grounds 1 and 2 until we know what's happened to ground A.
Yes. And then if they are all address, it would be listed for a day.
Yes.
If it was simply the original 2 grounds, it would be listed for half a day.
Yes.
Can I, while you're here, and this is anything else on that, I just wanted to understand just very briefly the relationship between regulations 11, 12 and 16.
Yes.
Which regulation 11 is right of admission,
Yes.
as it says, I'm only reading it. 12 is issue of an EEA family permit,
Yes.
and that is, again, because it's talking about an entry clearance officer, so it's admission.
It is, yes, it's the document.
Exactly. And regulation 16, derivative right to reside, is you have a derivative right to reside. One of the criteria is 16(2)(b)(3), resides in the United Kingdom as a self-sufficient person.
So there are various derivative rights to reside. So your Lordship may or may not have heard of what is called a Chen right. So for example, if a French child were in this country, but obviously was 1 year old, couldn't work or support themselves,
yes.
but their parent was self-sufficient, under EU law that was called a Chen right, and their primary carer had a right of residence. So
I understand that, but at the date of the application in this case, as I understood it, nobody was residing in the UK.
that's right. There still is a right of admission if the relevant, or there isn't anymore, if the relevant criteria were satisfied. In this case, it's a Regulation 16(5) case because it's what's called the Zambrano right.
Yes.
So,
And that gives you a right of admission.
yes, and it can also, if you're already here.
I understand that.
Yes.
Right, okay.
I'm so sorry, my lord. Could I just turn my back for a moment? So Regulation 16 is fundamentally for in-country, but Regulation 11 cross-refers to it. So to have your right of admission, you need to meet the relevant criteria in Regulation 16. That's one way of having a right of admission. Or
But it's through 11.
It's through 11.
And which paragraph in 11?
It's 11(5).
11.
So sorry, let me just check my skeleton. It is.
So,
11(5)(e).
and a regulation 11 did survive.
Yes.
So the question I had is, if the primary right survived, why the non-survival of Regulation 16 impacted on Regulation 11? Don't answer that question, but that's what was puzzling me.
Yes.
And you would have an answer to that.
Yes, and it's
Okay.
anticipated to some extent in paragraph 33(2) of
Right.
the skeleton.
Okay.
What the court may wish to know, just out of intellectual curiosity, is that some rights did survive and some didn't.
No, I understand
So-
that, but I was looking at this specific
Yes.
case and trying to work out, because if the primary right is still there and it's just the add-on, so to speak,
Well,
it's
indeed, and I absolutely understand why your lordship raises it, and we've anticipated it. The short answer is that the primary right is only half a right, because a right of admission is meaningless if there isn't any
But I-
substantive.
sorry, no, go on.
No, I was just going to say, arising out of this, I think I've understood that, having produced one rabbit out from under your wig, there isn't going to be another one, namely that, they didn't have the right anyhow as they weren't here in the first place.
No.
That's not going to be an argument.
Yeah.
No.
But also, you would have persuaded us, or would persuade us, that it's an important point, and also this is a difficult point.
It's difficult.
Yeah.
Yes, absolutely.
Yeah.
And it might help if you were going to be drafting an order arising out of this, for there to be a recital to that effect.
Upon the court noting
Upon
that it raises difficulty.
upon the court noting that the ground A raises an important and difficult, whatever the terminology is in PD3F, and the court,
So the court
being satisfied
yeah.
that it would be inappropriate for that issue to be decided without proper argument, however you want to describe it, from both sides. Can I just raise one other point, and that is the respondents. The respondents, and well, there are 3 respondents. I think they are all now adult.
Yes.
The first respondent has indicated that he is now acting in person. I don't know whether, I assume the solicitors were acting for all 3.
Yes, they were.
Right. So but we haven't got a notice of acting in person for respondents 2 and 3.
No, we haven't. We haven't had that.
Right. Okay. So that's one thing that might need to be considered, and the other is the respondents have to be notified of what's happening. Okay, they've said that they are not going to actively engage with the proceedings, but that doesn't mean we can ignore them completely. The first respondent's given an address, an email address for service. Sorry, an email address. I assume it's an address for service in accordance with the rules. So the first respondent will need to be served with this order, and I think you will need to make inquiries to seek to establish the positions of the second and third respondents.
Can I just turn my back to
Yes.
check their ages? Because I thought that he was their father, and I'm not
He
sure
is,
that
but
they
time
are.
has gone on.
But
No, I do. So there's some document that sets out their ages or their birth dates. I can't remember which one it is.
Well, there are. I'm looking at the FTT decision, and we may be talking here about appellants born in 2006 and 2002.
yes,
That sounds right.
January 2006. So
Yeah.
they would all, both of them, be adult.
we can certainly check that, because if one of them is not, then obviously additional steps would need to be taken. I'm being told they're all adults, so that makes things slightly easier. Substantively, it's fair to say that to the extent that, well, 2 points. One, once they're adults, it would be much more difficult for them to succeed based on their father. And second, if their father weren't pursuing his application, that would make it even more difficult, because theirs is a derivative right of a derivative right, in a sense.
I understand all that.
Yeah, so but we will make sure, insofar as we can, that formal steps are taken. I know that those instructing me have done a lot of work to try and liaise with what were the solicitors, and they will obviously do what they can to affect service, and if there is no correspondence address, then to take whatever steps are necessary.
So the obligation under the rules is not on the former solicitors, but on the party themselves to file the relevant notice and give an address for service. Presumably the address for service has to be in this country. Doesn't matter. Okay, but
We'll look at that.
Well, the order had better make provision for how they are in fact going to be served, which would seem to be by email to the father.
Yes.
For transmission to others.
Yes. I assume we can do that. As my Lord's made a good point, that we should include within the order that you have permission to serve respondents 2 and 3 by serving on the email address provided by the first respondent.
That's very helpful, yes, and that sounds right to me, but we'll make sure we'll go back and check the rule on that. But yes, that would be very helpful.
And in practice, it needn't say anything about it. You're going to want to tell to refer all the stuff that comes out of this to you.
My lord, the other point I should raise is that the solicitors have not filed what is called a Form N244, an application notice, which is to come in.
I thought they had, but I haven't. Have you got it on your? Alan, does that ring a bell? Have they filed the solicitors in this case?
Not that I could see, but when I looked
Oh.
over the previous few days, the notice of change came from
Party, not the solicitors. Okay.
It doesn't necessarily have to be done, but if that is done, that avoids the need for the respondents to take certain steps in person. What I do know from old days of appearing in the county court is that when there is an application to come off the record, the other party doesn't see it, so we wouldn't have seen it if it.
Yes, I see. Sorry, what I had been thinking of is a message from the Civil Appeals Office saying that a Form N434 has now been filed by the respondent seeking to remove his solicitors from the record. So rather in the same ways that the respondent is not pursuing his appeal, he's also seeking to remove his solicitors from the record when in fact it happens the other way.
But can we require the solicitors to file a form, whatever you said it was, N4?
N434.
I don't think so, but I would be guessing.
I'm sorry?
I don't know the answer to that question. What this court can require.
So? Yeah.
Sorry,
Yeah,
who's that from?
it's the same.
Yes, that's what I'm reading, which is from Sam.
Yeah.
So the N244 would be filed by the solicitors. Absent the N244, the respondents personally file an N434. But as the court has observed, only one of them has done that.
Yes.
But my understanding is the court can't force anybody to do anything. Certainly not can't. Well, I don't know is the answer.
Well, I think you should probably write to the solicitors just seeking their confirmation that they are no longer acting for any of the respondents.
So can that be closed off within the draft order, please?
Yes.
As to what is being done to regularise
that
position. I hadn't been aware that it's a two-way street, that the solicitor can apply to come off and the individual can apply for the and to become unrepresented.
We will just. There may well be previous experience of this and do previous orders within GLD. So if the court could allow us a little time to put this order together,
yes, absolutely.
Sure. I'm very grateful.
Yeah. And just returning once again to the main course of this.
Yes.
The entry clearance officer you are yourself satisfied that there are enough cases in the system to make all of this worthwhile. Because, I mean, if this is all happening for the sake of a couple of old cases, only one of them reported and not on point, and this is all based, is it, on your perception that there are actually meaningful cases within the system that require a decision about this, otherwise there's going to be trouble down the line?
Yes, with the caveat that it isn't possible to draw what the cases are out of the system. So in a sense, it's a general understanding. If your lordship would like us to, we can.
No. It must be a matter of feel, but
it's feeling. Yes, it is. The other difficulty, of course, is that there is a decision of the upper tribunal which says this person meets Regulation 16. I realise that your lordship's question goes to ground A rather than the other two.
yes.
My instructions are that there is a need to resolve this issue, but how many cases, where they are, we simply don't know. So I can't at the moment say more than that.
Just accept that. Yeah. Okay. Thank you. Is there anything else?
Not from me.
No. Well, thank you very much for your help. And can you, when you've got the draft order, can you send it to my clerk, please?
Yes. If in the course of our researches, a point comes up that we need to explain to the court, we will of course put a short note in.
Thank you. Yeah.
Thank you.
Thank you very much.